Thank you for joining us today. My name is John Sluice with Entrust CPA, and then we've got
Andrew Nichols with Integrated Payroll.
We're coming to you to give you a little bit of an update of the ESTA, which stands for the
Earned Sick Time Act.
And that's the new law in Michigan that's in effect for some of you and coming into effect for others of you related to sick time. Now, you're going to note I said accounting and he said payroll. We're not attorneys. We're not labor attorneys. We don't know the law. We're not legislation. But what we're coming to you today is that we're getting this question on a regular basis. Does this apply to me? What do I need to do? And so we wanted to take a chance here to just give you some high-level things to think about that you can use to either implement or update or change your policies to make sure that you're at least thinking through these things. Andrew, what's probably one of the number one question that you're getting off of this?
Well, the first question is always, does my existing PTO policy comply with the new ESTA requirements? And the first thing I would recommend is going on to michigan.gov, LEO. They've got a really good fact sheet and a flow chart to decide, which category you're in, what size business you are, what kind of accrual method do you currently do with your policy? Is it front-loaded or is it per hour worked? From there, you can determine where your gaps in your policy are in order to get compliant.
And I guess I'd answer that question, and I would agree that that's probably the most common, which is, am I good? Do I need to do anything? I would dare say that you should assume that you are going to have to do some updates. You might find that you're close, but there's very few that I've run into that don't have at least some little tweak that you have to do to make sure that you are compliant in there. Said another way, most employers offer PTO. So they say, well, I give PTO. That will be enough, won't it? And my answer to that is maybe. Because keep in mind, a front-loaded PTO approach does work, but it also means that you have to have every other part of the compliance requirements that are inside of that. So are you giving enough PTO? Do you give it soon enough? Do you allow for the approval process to be as short-windowed as what sick time is? Does it carry over? So there's lots of nuances inside of it that you might have to look. And you might find that you're close, but you do have a few tweaks. And so I would dare say you should assume that you should be looking at your policy and asking, okay, what has to be updated or changed, and working with an employment lawyer or maybe a trade organization or something like that that can give you guidance on that too. So.
Yeah. The one thing that we're seeing come in from a lot of our clients is that their existing PTO policy fits for the most of their tiers, if it's a tiered plan, but the very first, the initial new hire day 0 to 1 year of employment is the piece that's going to have to get modified to fit the new laws.
Right, because essentially for most employers have to it's either between 40 hours or 72, depends on if you're a large or a small employer. But to give you an example, most plans would say, okay, from 0 days to a year, either there's no vacation or maybe a week's vacation. Well, this now requires that it's much sooner and much higher balance for that. So that hits into a little bit next topic here of the difference between a large employer and a small employer. That's a fairly known thing, but can you share what that is?
Yeah, the state defines it as 10 employees or less is going to be considered a small employer, and anything more is a large employer.
And so if you're a large employer, this is currently in place and going and working, and you must be compliant now?
Yep, effective February 21, you'll have to offer the earned time back to that date. You may not have your policy ready to go quite yet. They did give you some grace period to update your policy, but you will backdate the earned accruals to that date.
And then if you're a small employer, which is 10 employees, it's 10 employees or less, or less than 10 employees?
10 employees or less.
Okay.
Yep, and that's up to 40 hours in a year.
And then that goes into effect?
October 1st.
So you have some time there. So if you have 10 employees or fewer, you do have time. You have until October 1st to get it in place. And many of you, that's probably where you're going to fit into, but that is something that you need to be thinking about, because believe me, it's going to come faster than you think it is. Now, that's fairly straightforward, and if you have any questions specifically, again, we'll have a link to the actual FAQs and the information on the state website below this, so that's pretty straightforward and clear. One thing that's not clear, and we don't know the answer yet, he doesn't know the answer yet, and they don't know the answer, they being the government, know the answer yet too, is do business owners count in this number, right? So if you have 9 employees or you have 10 employees and then plus yourself as the business owner, does that push you over? That is not a known thing. I'm going to give you one of my thoughts, and I'll have Andrew give his thoughts, but we're going to be very clear, they don't know that yet, because there's an example of it's really easy to make this theory of this idea of what they want to do, and then the details come out and they have to be figured out. I would anticipate some guidance coming in down the road on this one sooner than later. To answer, well, let's ask you, what are your thoughts on that? How are you responding?
Best practice right now, I think, would be to consider yourself an employee until it's determined, and follow the guidelines. But pretty quickly, we'll learn as it gets implemented, as people have to engage with the policy, answers will come to light, and you can always modify your policy at that point.
Yeah, I would concur, Andrew, that if we want to be conservative, and as an accountant I always say we should at least start out being conservative, assume that you're an employee and you, as a business owner, that you're counted in there. Now, to give a little nuance to where I think it may go is it's probably going to follow the regular laws that are there, which would imply that if you're a partnership, you're technically not an employee, and since you're not an employee, it wouldn't be counted. But if you're an LLC taxed as an S Corp, you therefore are an employee, and then I would assume you would be counted in, and then if corporation, you are going to be an employee. That would be my assumption right now. Now they may change that, right? Because, for example, state unemployment has different exemptions there as well, so it's very possible that you would be exempted. But as of right now, conservatively assume that you are in the number. Maybe give yourself a little wiggle room if you're a partnership or a sole proprietor. That might be in there too. So, and then Andrew, you brought up another point here on just how do you even determine the number of employees you have and the complexities that go into that?
Yeah, you're going to be looking for your full-time employees year-round, but for the seasonal or part-time hires, which a lot of our clients have, there's going to be a guideline about the number of weeks they work in a year, whether they count towards that number or not. So you'll want to, do a record of, or make a record of what hours are expected and duration of employment for your seasonal employees is going to be to decide whether it pushes you up or you can remain a lower small business.
Yeah. And many of these tracking options to do this are both determined up front when you document the hiring and what the expected role is, but it's also documented within the historical information from like your payroll provider or your timekeeping software that's there. So,
yeah. I would say a lot of these situations that come up that you're going to be able to do a retroactive look back accrual to see how much they should have earned, and there'll probably be some leeway with resolving any discrepancies or issues that come up.
So another question that business owners that frequently that I'm talking with are asking is, well, if I give it up front, then do I count or do I have to accrue it? And the answer to that is you are able to give it up front. They did come back and change that and said, sure, you can front load it. I smile at that because I'm sure they'll also tell you can give everyone your employees a bonus as well, right? So it's written to be favorable towards the employee in this case. So you can front load it if you wish, but you are able to also have a strategy that says they can accrue it up over time. So both are allowed and both are able to be used and calculated. So
yeah, we're seeing a lot of our clients remain with a front-loaded policy because the guidelines say you can. You don't then have to carry it over. You don't have to track it per hour. It's a little more lenient if you favor the employee and give it to them up front.
One of the things you do have to watch for, especially if you're thinking of the front loading, the plan or the existing plan that you have in place, many employers do it off of anniversary date. So when you start on if you started on September 22nd, that's when you get your reward or awarded period. That doesn't qualify anymore. That's not front load because you have to think about it that they have to be able to use it on January 2nd. And do they have that information? Do they have that right then? There is going to be the question of whether it kind of carries forward and does that count, but there is this initial implementation period that you also have to think about. So if you are doing front loading and you're doing an anniversary date, you may have to consider some updates and some ramifications there. Well, a question I get asked a lot, and again, I'm in the accounting world, not the payroll world, is, well, can you guys help track this? And the answer to that is your software should be able to. And so,
yeah, your existing payroll software is going to be able to accrue or log your hours worked and then therefore build an accrual off of that. If you want to go one step further, you can have a timekeeping system that would accrue it per the minute, per the second as it is earned and worked.
Well, so one question I get asked a lot, and I can even, after you answer the question, give an example of what we're doing here, is can I do a split of this, or do I have to do all in or all out, or what's allowed there?
We don't know officially, but the state also doesn't say you can't. So for now, we are seeing a lot of clients keep the core of their existing policy in place and then adding one piece to satisfy and make you compliant, even if that is something that changes from a front loading to an accrual base. Yeah. A lot of our clients had consolidated PTO into one single bucket, and now we're seeing a trend the other direction to split out general PTO and then the sick time to get compliant, even if it's accrued differently.
I know that's what we as a firm did, is we had gone to a single consolidated bucket and we're in the process of splitting them out. And interesting enough to answer that as well, we took this as an opportunity to look at what was some confusion that we had in our existing policy and use this as a reason to say if we have to modify it anyway, let's clean that up. Well, one of the confusion that came out of having a consolidated bucket was that formal approval process ahead of time, right? So we had said in there you have to ask for 14 days ahead. Well, what defines when someone's sick and it's not, right? So the point of this is to provide that clarity that's there. Well, by us, what we're doing is we're separating it out and we're saying, well, PTO and vacation is really vacation. That's going to have that 14-day approval process, and then sick time is the shorter approval process time. And so we're to give clarity for the time, like when do you need approvals or not. So it is a good opportunity to take advantage of some of those things that are in a policy that you want to provide more clarity. Or if you have things in your policy that you've done this way forever and ever and you wish that you can change it, well, now's a good chance that you can change it, and we can blame it on the new law, and it's going to be able to be passed on to the employees a little bit easier. But I mean, on that end, Andrew, you brought up that about the employees. Can you share your thought there?
One of the things that the employees are having a hard time grappling with is if a policy does split from a single PTO bucket to a vacation and a sick is, I have less time, but really that sick time can be used for quite a bit and a lot that they were already using their PTO for.
Andrew, do you have any other questions that you're getting quite frequently?
Yeah, with all the changes of the PTO policy, some people are trying to use their existing, but they also need to have a written policy out there that details how the sick time is compliant or how it's going to be used.
So for those of you that have just kind of had a this is what we've always done type of approach, this is a good opportunity for you to really go through and document and update, make a policy in place. That brings up a good question that I get actually quite frequently, and I can't tell you the official answer of this, but well, why do I even need to comply, and what's the ramifications, and what happens if I don't comply? This is where I'm not going to give an opinion of what does or doesn't happen, but what I would say is where you're going to find it is when you have that one employee that is the disgruntled one, right? It's going to be similar with complying with any other employment law type item, which is, you're right, there's not necessarily that proactive enforcement out there, but you're going to wish you had it in the event that you have the one employee that calls and complains. So I don't want you to be scared of this. In fact, I want to say the opposite, that use this as an opportunity to beef up what you have, use it as an opportunity to provide clarity or consistency with things that are questions, and use it for advantage of talking about raises or otherwise. So don't do it out of fear, but fundamentally I do see that that's where it's going to get monitored. Ultimately, this isn't going to give you every single answer for every question you have related to this. Our goal of this was just to make sure that you're aware of it, and as a business owner, if you have any employees you need in Michigan, you need to be thinking about this. It's not going away. For myself, I had hoped actually that it was going to go away, but they did amend it and change it in the very last minute, and they didn't make it go away. They changed to become more favorable, and it is in law now. And so it's not going away. It's something you have to be looking at, and if you have employees, even one, it will impact you. And while you may be okay with your existing policy, chances are you're probably going to have to at least make some tweaks or a lot of tweaks. So you should be looking at it. And if you have more than 10 employees, it's in place now. And so you should be looking at it sooner than later. Less than 10 employees, and you have until October, but you should start now as well. So we're here to answer questions to the extent that we can. Andrew's available for questions as well. Definitely reach out to your HR specialist and or your labor attorney as well. But we're here to answer any questions we can. Thank you for joining us and look forward to talking soon.